Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. My guest today is Christine Nentwig, an attorney with CGA Law Firm in York. And Christine does mainly employment law, representing a number of employers mainly in York County. And the topic today is sexual harassment in the workplace. I know that there's been a lot in the news about sexual harassment in general. We're concentrating on sexual harassment in the workplace. So welcome, Christine.
Thank you, Tom. I'm happy to be here.
Okay, and I'm going to start with the first question, and that is for you to define sexual harassment.
Well, sexual harassment, the textbook definition would be unwelcome, unwanted advances, sexual advances, or obscene remarks, gestures, that sort of thing. Okay,
and I think that it can be broken down into verbal.
It can. It can be comments. It could be sexually explicit jokes, things that people say.
It could be physical contact.
It could be physical contact. It could be groping, touching, pinching, I could go on, but...
And it can also be what you categorized when we was preparing as visual.
Yeah, if I make a gesture or, I hang an inappropriate poster or something in my workspace, that might not in and of itself be harassing, but it could contribute to a hostile work environment.
Well, it could make another employee uncomfortable if you hung a photograph that was somehow suggestive or inappropriate.
Well, right. So like when I first started working a while ago, I won't say how many years, the tool calendars, and they may still be out there, but in some of the manufacturing environments, some of the tool companies would have these, sort of buxom ladies on their calendars, and they would send those out to people and they would display them proudly in their workspaces. And that, that sort of display was problematic because female employees working in that environment might look at those posters and not be comfortable with them. So, you've seen that sort of go away, but, we still have, now we have screensavers and we've got, what people might display on their phones. So all those things. I will mention one other thing that comes up quite a bit is now that we have smartphones, people are bringing inappropriate videos and photographs on those into the workplace. That too could contribute to.
And so this would be something that, again, your concentration is employment law, so you're dealing with the harassment that occurs in the workplace.
That's right.
And this would be something that could cause an employee basically to be either outright inappropriately harassed or uncomfortable.
Right.
So
a gradient. There are certain things that are, like you say, troublesome, bothersome, but maybe not so egregious. And then that goes all the way up to...
So when determining what is sexual harassment, I think, like the quote from the Supreme Court, I know pornography when I see it. But when it comes to the gray areas, one of my questions as we were preparing for this was, is this an objective standard or is it a subjective standard based upon the individual who feels offended?
Well, I think it's a little bit of both. When we talk about, sexual harassment, we talk about hostile work environments, we do look at, or I shouldn't say we, but the EEOC, the Equal Employment Opportunity Commission, a jury, they would be looking at the effect that the conduct had on the individual, not necessarily the intent that the person who, made the comment or hung the picture had. But so that part of it becomes subjective because if you're dealing with how someone reacts, that's, again, going to just by virtue of their reaction be subjective. But my point is, the way that they've tried to objectify that is and make it a little bit less subjective is by requiring that, first of all, the reaction be reasonable. So they look at it as the reasonable person standard. How would someone in a similar situation, how would most people in that situation react? So if someone is hypersensitive or they take something completely out of context, that generally is not going to be considered to be, actual harassment. The other thing is that in order for it to create a hostile work environment, for whatever conduct it is to create a hostile work environment, it has to be either severe or pervasive. So, if I tell one off-color joke one time, that in and of itself likely is not pervasive. It's not going to rise, and it's not severe. So it wouldn't rise to the level of creating a hostile work environment or constituting, full-blown harassment. But if I do that, every day or, several times a day over the course of a period of time, that can change that. And then, of course, severe is severe, so what we think of as being sort of automatic is touching, any sort of groping, inappropriate pinching, whatever. Those kinds of things tend to move it very quickly into, automatically being considered inappropriate.
And what is the obligation of an employer to protect its employees from sexual harassment?
Well, I mean, first of all, I guess I should start by, there are two sort of varieties of sexual harassment. One is where it involves a supervisor, and that's the quid pro quo sexual harassment scenario where, essentially there's an exchange. So I'm a supervisor, I have hiring, firing, power over an employee, and I make being subjected to or being complicit with sexual harassment a condition of employment. In that case, the employer has a far greater obligation to prevent and be aware of it because essentially that supervisor, that manager is acting as an agent of the employer. So in those cases, I need to make sure that I'm, number one, training my managers that they know right from wrong, they know what they can and can't do. But I'm going to also be tasked with some degree of knowledge. So I have to be monitoring what's going on in the workplace there, more so than I would where we're talking about employee-to-employee interactions.
Okay, so there's a higher standard for a manager?
Absolutely.
Okay.
Yeah, absolutely. I mean, they, again, because you're acting as an agent of the company. And so, if I'm engaging in harassing conduct, if I'm making, being subject to those sorts of demands a condition of employment, I'm now, basically putting my employer in a very precarious position.
Well, yes, and I think I would imagine that the difficult part was, is it a condition of employment or is it perceived as a condition of employment?
That's right. I mean, and there, again, there's no absolute answer to that. I mean, it's the effect on the person.
So if someone's boss, if you're working in a department at a company and your direct supervisor is constantly telling you dirty jokes and you don't like it,
and I quit because of it,
then
I could say, well, that was a constructive discharge. I felt as though, I was being made to feel so uncomfortable in that situation. I felt that I had no choice but to, leave employment to get away from it.
And what would the remedy be for such an employee?
Well, I mean, depending. First of all, I'm not saying necessarily that wins. Whether or not something is so severe that it warrants quitting versus going to the employer and complaining is an open question also. I'm not sure, again, I'm not sure dirty jokes alone would be enough to justify, that, hey, I'm just going to up and quit. I'm not even going to go to management and say, I've got a problem, can you help me fix it? But the remedy, assuming first of all, if the person did go and complain, the remedy there might be, counseling or coaching the employees who's telling the jokes, telling them to stop doing it. It might be separating them, moving them to different departments so they don't interact. It might be, depending on how egregious or how often, it could be, termination. But, you'd have to take some action basically to prevent that from happening again. If the person quit and then said it was a constructive discharge, I think that's a little bit more challenging because now the remedy might be back pay. I've lost my income, I've lost my earnings. It might be front pay.
Now, is this something, when you're saying the remedy, is this something that, for example, would be in a lawsuit?
It might be, right. I mean, when I'm talking about the internal complaint initially, I mean, hopefully we're not at the stage of litigation. And that's what we as employers are always hoping, is that people will come forward and we won't have to litigate. We can address and correct the problem short of litigation. But if we have a situation where it was not remedied internally and the person now has gone to an outside agency and subsequently brought a lawsuit, then.
So you mainly represent employers, so what's your advice to employers for how to handle this?
Well, I think the most important thing, and probably the hardest sell for me as an employment lawyer, is to not wait for the issue to crop up. Don't wait for the complaint, don't wait for the charge. Instead, and especially now, because with what you mentioned at the beginning, it's in the news, people are very aware of it, people are cognizant of it. And so to me, this is a prime opportunity for employers to get ahead of this and say, okay, first of all, do we have an anti-harassment policy? And a lot of employers, even some employers that are larger, either don't have one or they have policies that are really quite out of date. So, when's the last time you updated that policy? Make sure that it reflects what your processes are, what your internal reporting procedure will be, and then communicate that to your workforce. Make sure that they understand, number one, here's what harassment is, here's what a hostile work environment is, here's the kind of conduct that, is not tolerated, and here's a process, here's a procedure for our employees if you feel that you've had a problem to come forward.
So basically, you have to make the workforce know that reporting this is not only something that they should do, but it's something that you want them to do.
Such an important point. And truthfully, I think a lot of employers secretly, and I don't blame them for this, it's like they don't want the complaint because that creates a whole lot of work, right?
It's like ignorance is bliss.
Right. Sometimes it's like I'd rather not know. My concern with that is if something simmers and festers and gets worse, and then, something else happens that triggers the employee, to get upset, now this all may come out and you've missed, you've not had an opportunity to address it while it was still, hopefully at a more minor, more easily remedied stage.
Because if something drastic happened, most likely that employee's not just going to tell you about that one incident, they're going to tell you about maybe a year's worth of other incidents that you were completely unaware of as the employer,
right,
that maybe you would have done something to remedy before the drastic incident occurred.
Exactly. It's the ounce of prevention, pound of cure. And, and I think, for employees, you made me think of a point when you were saying that, which is, once something gets so far gone, then often an employer will say, well, wait a minute, they can't complain now. They should have told us about this 6 months ago or 9 months ago. It's too late. And, unfortunately, the law is structured, and these, the agencies in particular, if an employee says, well, the reason I didn't come forward was because I didn't know about the policy, or, I was led to believe that management didn't care or didn't want to hear my complaint, or worst case scenario, I tried. Maybe I did talk to someone and they said, oh, well, that's just Joe, go back and let me know if something worse happens, but that's just kind of how he is. Those are, then you were on notice and then you didn't do anything.
Okay, so the bottom line is that there should be a policy.
Yes.
And the policy should be followed, and the workforce should know what the policy is.
Yeah, and I really think in addition to the workforce knowing what the policy is, special attention should be paid to making sure your supervisors and managers know the policies, because they're your front line. And if they don't understand the process, if they don't understand where the issues might arise, number one, they may not spot something that's right there in front of them. They may not realize, or worse yet, they may think, well, I don't really want to bring this up because I'm not sure my manager wants to hear about it.
Okay, I hate to interrupt you here, but we're out of time for the first segment, but we'll be coming back in a few minutes.
Okay.
Welcome back to Legal Lines. Our guest today is attorney Christine Nentwig, an attorney with CGA Law Firm who handles employment law cases, and our topic is sexual harassment in the workplace. Welcome back, Christine.
Thank you, Tom.
As we said in the first half, you deal mainly with the employers, and one of the things you said, which I remember, is an ounce of prevention is worth a pound of cure. And what you meant by that is let the employers know how to handle the situation before it arises so that there's a policy in place as to what should be done. And I know that one of the things you do as an attorney is you present to your clients how to deal with sexual harassment. You talk to management as well as the employees, and I want you to tell us what you tell them.
Well, I don't have time to do that because it takes about 90 minutes.
Oh, wow. We're not asking you for the 90 minutes. We're asking for the condensed
We'll give you
version.
the Reader's Digest version. No, I mean, first of all, I always tell employers when they ask me to come out that it truly is my favorite part of my job is getting to go out and, meet with their managers, meet with their employees, and, help prevent issues before they come up. Obviously a lot of what we do is, we get the charge, we get the complaint, we get the big file on the desk, and, the cow has left the barn, so to speak, and the issue's already is what it is, and we're just trying to make the best case for our client. To have the opportunity to avoid that in the first place, is something that I'm always happy to have the chance to do, because as much as I enjoy doing litigation, I also enjoy seeing my clients avoid that.
And you might enjoy the litigation, but I can guarantee you the parties do not.
The parties do not. I always say,
enjoy it.
I don't know if I'm supposed to say this on TV, but the only people who win in litigation are usually the lawyers, right? So anyway, we try very hard to get our clients to, take that step and be proactive. And so when I get the chance to go out, I try to drive home a couple of, really key points. One is, making sure that managers and employees understand that the policy is there as a framework, that it may prohibit more than the law does. And so really we have to look to the policy as the key. I don't think people should get so caught up with, trying to understand what the law is. The employer sort of creates their house rule, and that is their policy, and so that's what we should really follow. Managers need to understand their special role, not only because, as we mentioned earlier, they can, if they're engaging in harassing or hostile conduct in the workplace, that carries far greater, risks and, liability for the employer. But they also have a special duty to spot and report issues. So we need them to sort of, I say get their antenna up and make sure that they're sort of on alert and they're watching for things in the workplace that, other folks who aren't trained, who aren't, looking for it, might go, oh, well, it just seems like harmless banter.
So the manager, obviously, the obvious one is the manager should not engage in such conduct.
Clearly not.
But the second part that isn't maybe as obvious to the manager is that they should stop the other people from engaging in such conduct.
Yes. And this is hard, especially, especially for younger I shouldn't say younger age-wise, but newer managers, newer supervisors, who haven't been managing very long. Sometimes there's the inclination to try to, I want to get along with my subordinates. I want to be friendly with them. I want them to like me. And it can be hard to be the sort of stick in the mud supervisor or manager that has to say, hey, don't tell jokes like that anymore. Or, hey, turn off the, Chris Rock video in the lunchroom. Those kinds of, they're going to have to take that extra step and sometimes be the bad guy in order to fulfill their obligation to make sure that this kind of thing isn't going on in the workplace. And if they don't do that, if they turn a blind eye, unfortunately, not only does it expose the employer to some liability, but it's also sending a message to the workforce that it's okay. If the people in charge aren't addressing it or worse are engaging in it, then that sort of sends the message that this is a culture that's okay.
Okay, so what you're doing is you're going into the company explaining to them, number one, what sexual harassment is, what it can include, how to deal with it, from what the responsibility of managers might be. But one of the things you said in the first segment is there needs to be some type of policy. Is that policy who to complain to, what lines of commands there may be?
Yes, I mean, definitely need to have a clear and, and a policy that includes a clear reporting procedure, makes it, crystal clear to an employee who do they go to. Maybe that's any manager, maybe that's human resources, but gives them as many options as possible. The other thing that's really critical to have in that policy is a clear prohibition on any sort of retaliation, which we didn't talk about previously, but that's sort of the one of the most important elements, because if employees fear retaliation, if they think that by reporting they're exposing themselves to potential, either I might lose my job, I might not get that promotion, they won't come forward. So that policy and when you do training, the managers need to have that reinforced too, that you can't take negative action. Now that doesn't mean that if someone complains that they suddenly have carte blanche and they can do anything they want, but it does mean, I think, that you have to be a little bit careful after you've received a complaint, that you're not inadvertently doing something that might be seen as retaliatory.
Okay. What do you tell the employees who are not in management, what their responsibilities are and what they should do if they feel they're being harassed?
Well, I mean, obviously, and it's an interesting point you raised, because I've seen policies, that are sort of, sort of dictatorial about it. Like, you must, report if you witness any form of harassment. There's no legal obligation on a coworker to do that. And I think that can put people in a difficult spot sometimes. So I do prefer to see it handled a little bit more, I don't want to say softly, but, in a way that encourages people to do it and, provides them with a supportive policy and network of people that they can report to. But I don't think I don't think that hammering it home in that sort of, in a harsh way is necessarily going to be super effective.
Okay. Well, does it depend on the type of the harassment?
Well, I mean, right. So you're saying if you witness something that...
Well, if let's say
if you witness a crime.
Well, if there's something that clearly would cross everyone's line or offend anyone, improper touching, improper, contact, as opposed to what someone might consider a dirty joke and somebody might laugh and somebody might think that it's offensive.
Yeah, I mean, again, you raise a very interesting point. I mean, again, I don't think there's any, even though we would believe it's the right thing to do, I don't know that there's an affirmative duty on a coworker, to come forward.
Would there be on a manager?
Absolutely, and that, that's where the distinction is. And if that, another thing that comes up, in the training is, and this happens with employees, where they'll go to a supervisor or manager and say, hey, I want to talk to you about something, but I want you to keep it confidential. Can you please not tell anyone? I just want to talk to you about this sort of off the record. The answer is we can't do that. There is no such thing as off the record with a supervisor or a manager. Once I become aware as a supervisor that there's any indication that there's a problem, I have an affirmative obligation then to go to HR, or if there's no HR, go to upper management and let them know about that. But again, I don't think that same, there's not that same obligation on a coworker. So I think that's why you have to thread that needle a little more carefully and try to, again, sort of lead by example, demonstrate through your actions as, an owner or a senior manager or whatever the case might be, that we don't tolerate it. Also demonstrate that we don't retaliate against people who come forward for these things. If there are issues, if there are complaints, show through examples that, you deal with them methodically, you deal with them fairly, and then, encourage people to come forward with issues, explain to them why it's important to do that. And that, I think, is going to be much more effective than trying to, sort of put a mandate in place that says you must.
Okay. So it sounds to me as though by doing this, the upper management needs to, number one, lead by example.
Absolutely.
Okay. And make it known that there is a policy in place that should be followed, and this type of conduct is not tolerated.
Yep.
does that help the employer if something should occur that the employer didn't know about?
Absolutely. I mean, that becomes their defense, which is, we had a policy, we communicated the policy, we trained our managers. Without that, they really don't have a defense. They don't have, the ability to argue that they made a good faith effort to prevent that in the workplace. So, and again, if senior management or managers are engaging in the conduct, then I think that pretty much directly undermines any argument that they aren't, that they were trying to create a workplace free of that.
Now, if somebody had a complaint against the employer in general, their manager, and the upper management does nothing, is there a place where they can go to complain?
Well, wait, repeat the question.
If you go through the hierarchy in the company and the company just
get all the way
ignores
to the
you.
top.
You get to the top and the company just ignores you, said, oh,
That's
you're
just
grown
Joe.
up, that's just Joe, that Joe does
Yeah.
that. Joe touches everyone that way, don't be offended.
Right. And the other way this happens, I mean, just beyond that is, well, go talk to Joe yourself. You go deal with it and let me know how it works out. And then I never hear anything again, so I just assume everything's fine. Yeah, I mean, if I try to use the procedure, if I try to complain and no one listens, then, unfortunately, the only resources outside of the employer at that point, and that's where, the agencies come in, the EEOC,
All right,
the PHRC.
and that's what I wanted you to talk about.
Yeah,
what are these agencies?
So the Equal Employment Opportunity Commission, the Pennsylvania Human Relations Commission, they essentially are tasked with enforcing, the anti-discrimination laws. And, sexual harassment falls under Title VII. And so, and there is a corollary, a corresponding provision in the Pennsylvania Human Relations Act. So, essentially they're sort of the first pass, if you will. They do the investigation. They determine whether or not they believe there's reason to believe that there was discrimination or harassment. And then, they may take the case forward themselves, or they may issue a right to sue and allow the person then to proceed to court. But they'd have to go to that agency first before they could go, directly to federal court.
So
or state court.
So it says the agency does the investigation.
That's right.
Determines whether or not there's a legitimate cause of action, and either the agency can do something for the appropriate remedy,
They can.
or they can just basically say you can litigate this.
Right, or they can litigate it on the person's behalf. So they have fairly a good number of options available to them in terms of enforcement. I would say probably that they're overwhelmed. That takes a long time for these charges to work through the system. I have had cases that have sat for 2 years or more, where they're investigated, they sit, they come back, they investigate a little more, they sit. So it's a long, drawn-out process, not only for the employee who initially complained, but for the employer.
Which is something the employer wants to avoid, should avoid, which takes us back to the fact that they should have a policy. And we have 15 seconds remaining. I'm going to say the employers, maybe they should contact you, let you talk to them to put the policy in place, or help them put a policy in place. And we're out of time. My guest was Christine Nentwig. This is Legal Lines.